Good morning, everyone. Good morning, esteemed colleagues and guests. Thank you for joining us for this BVI Finance Breakfast Forum, where we will discuss a critical policy document, the rights of access to the Register of Beneficial Ownership. The consultation on this policy was launched on January 17th, 2025, and has now been open for feedback for several weeks. As this remains an ongoing consultation, the final outcome has not yet been determined. Your participation today is vital in ensuring that all perspectives are considered as this process is being refined and the framework is being aligned. I am Elise Donovan for BVI Finance, and I am your moderator for today's session. And I'm pleased to be joined by Ms. Ayanna Glasgow. She is the Executive Director of International Business Regulations in the Ministry of Financial Services, Economic Development, and Digital Transformation. Ayanna will provide an overview of the consultation, explaining the key considerations, the objectives behind the policy, and how it aligns with both the international standards and BVI's commitment to responsible financial services regulation. Following Ayanna's presentation, we will open the floor for questions. So please go ahead and start providing your questions in the Q&A box, and we'll address them in the ongoing discussion. This is a very important dialogue for this jurisdiction, and we appreciate your participation, and we appreciate so many of you joining us to help shape the future of BVI's regulatory framework for beneficial ownership. With that, I will now hand over to Ayanna Glasgow for an overview of the consultation. Ayanna, thank you so much for joining us, and we're pleased to have you on the BVI Finance Breakfast Forum.
Thank you, Elise, and good morning, good afternoon, good evening, good night to all of you joining. I'm sure there are many in different time zones, and I can say on behalf of the government of the Virgin Islands that we're very pleased to see that persons have recognized how critically important this consultation process is and has to be to, in order, as Elise has said, get it right. Now, what I wanted to start with is how did we get here? And then take a look at key components of the policy document, obviously not going over it verbatim, but pulling out a couple of pieces that I think are pretty important. And then we can open for questions. I really want to focus on what the participants are interested in hearing about, so that we can make sure that whatever is received formally through the consultation process is not subject to any misunderstandings, or that clarity is not optimal. So how did we get here? A decade ago, or over a decade ago, there was a conversation that started around public access to beneficial ownership information. Back then, views were sought from the industry, not privy to what those views were, but ultimately what happened, we eventually introduced the beneficial ownership secure cert system, commonly known as BOSS, and engaged with the United Kingdom with exchange of notes that essentially allowed BVI law enforcement to provide information to UK law enforcement through a formal channel. Notwithstanding all of that, commitments were still made to introduce publicly accessible registers of beneficial owners, commonly now referred to as PARBOs. Obviously, all the jurisdictions were committed to that, but then the European Court of Justice ruling that happened in 2022 caused OTs and Crown dependencies to take a look at whether or not they needed to revisit that. And recommitments were made, BVI included, to introduce a register of beneficial ownership that is accessible through a legitimate interest framework. Now, I want to take the opportunity at this stage to thank the focus group that the government convened to discuss this draft policy document that's now being circulated. The Financial Services Commission, along with ourselves and that focus group, really developed and looked at whether or not this draft policy was ready for distribution widely. So I want to take this opportunity to thank them because it was very crucial to fine-tuning some of the provisions and really putting out a document that we feel would give us the best possible feedback from stakeholders. Now, the BVI has never shied away from its responsibility in fighting illicit activity, and I think it's evident in a lot that has happened, not only in the amendments to various pieces of legislation, but also the work that's been ongoing, even with our remediation efforts on the mutual evaluation exercise. But one of the things that we want to do is ensure that we remain trusted and competitive, and that whatever we do in this legitimate interest space allows us the opportunity to balance transparency and privacy. So, again, I reiterate the importance of receiving stakeholder feedback because that, in essence, will be critical to the success of this consultation process. Now, turning to the document itself, um, who currently has access and who could potentially have access under this legitimate interest draft that we've put to you. Currently, access to the register of beneficial owners lies with domestic law enforcement and competent authorities. Now, I mentioned earlier about the UK exchange of notes, and we've essentially transposed that very framework into the new legislation that has been passed. So the regulations, the beneficial ownership regulations that you all will be familiar with, allows access to beneficial ownership information by domestic law enforcement and competent authorities, and the Financial Investigation Agency remains the gatekeeper of the information that is shared with the UK law enforcement authorities. Now, the eligible categories that we've put forward in this draft policy document um, were put together based on what we've assessed that's happening around the globe. Now, Elise spoke about international standards. Now, it is not yet an international standard as to what a legitimate interest register of beneficial ownership should look like. But we've certainly observed what other jurisdictions have been doing, have been consulting on, and essentially have themselves, in some instances, introduced. So the categories that you have before you in this policy document refer firstly to domestic regulated financial institutions, domestic nonprofit organizations, domestically supervised designated financial, non-financial businesses and professions. We've also included civil society organizations, we've included media and academics. All of these we've seen in different platforms across various jurisdictions. One of the things when we speak to balancing privacy and transparency is around the protection and potential exemption clauses that we put forward as well in this consultation document. And it's basically coming in twofold. The first speaks to if a person qualifies for legitimate interest access um, as one of these pieces of this eligible categories that we've put forward, they will only have access to limited information. That limited information is identified in, I think, paragraph 6 of the document, referring to only the name, month and year of birth, nationality, country of birth, and obviously nature of ownership. The second prong relates to exemptions which can be granted to beneficial owners who are concerned about kidnapping or other types of activity of that nature, who may be minors or incapacitated persons, and also possibly public interest concerns. And public interest concerns could speak to national security matters. Now, I want to say that exemptions are subject to a review. If they are granted, for example, taking the most simple one, a minor, obviously, if a minor is granted exemption, they will eventually reach the age of majority, and as such, that exemption would fall away. So that is how it is anticipated that exemption will work. Generally, the process itself, and I mentioned that the Financial Services Commission was involved as well, because as you all know, they are now essentially the stewards of the Register of Beneficial Ownership, and it's very important that they are involved in how the policy evolves and also contribute, because at the end of the day, it has to be something that they can administer. It is expected, um, just giving a very broad view, that if access is granted, let's say you have a beneficial owner. Well, let me start over. You will note from the policy document that a beneficial owner can be made aware that a request has been made for their information, and they're given a specific period of time by which to put forward to the registrar reasons why this information should or should not be shared. If that beneficial owner provides compelling reasons why the information should not be shared, the registrar takes all that's provided into consideration and then makes a decision. The decision will either be to grant access or to refuse access. Either way, either decision, we have implemented or are considering an appeal process. We already have a financial services appeal board that already exists, that already has responsibility for um, appeals related to financial services decisions. So that would be the first point of appeal. And again, the appeal process is open to both the beneficial owner and to the person that has made the request, depending on who is aggrieved by the decision taken. Um, and then that will work its process. I think another key point that will raise, and then I will open, Elise, is the search cost. So we have historically, Virgin has had a search function, and that search has always been at a cost. There is no intention, based on the policy that we put forward, and we would appreciate feedback on that. The position is to charge a fee, as we have always done for searches of the registry system. So we are not intentionally putting a fee on this search just because it's beneficial ownership information. Those of you who practice in the industry are very well aware that searches have always been, since the inception of our electronic system, at a cost. So I will leave it there, and I will, open up, Elise, for persons to raise anything that they wish to raise on the policy document.
Thank you very much, Ayana, for that insightful overview and outlining to us where we are at this stage and trying to find that right balance between transparency and balancing the right to privacy. Looking at where we are with this consultation, and it provides the right to access with their potential risk of exposure or abuse. How are you addressing that within the framework?
Well, as I mentioned, there is the process that is there to grant exemptions. There is the process to permit appeals, and then of course the allowing, because again, we are stewards of information, so we have now become responsible for lots of data around a beneficial owner that has a BVI company, and as such we have to manage that data responsibly. So with the mechanisms we're proposing to introduce around notifications to the beneficial owner that their information has been requested, and giving them the opportunity to request exemptions, I think are useful tools to enable us the ability to balance that privacy concern that may be very, very reasonable for a beneficial owner to have. Because again, historically, as you know, beneficial owners, there was no um, there was no concern when, in my opinion, BOSS was introduced, because there's an expectation that law enforcement and competent authorities would have access anyway, whether they came into the registered agent's office or they actually are receiving it through the electronic system that we've now created. So that's always been an understanding. But I think obviously there's a lot of apprehension around other persons outside of those groups having access. And that is a fair concern to have, which again goes back to responses required formally around what we're proposing to do and whether or not that alleviates concerns about data being shared, um, I guess, based on fishing expeditions versus real activity towards fighting illicit activity.
Legitimate interest. We have a couple of questions already in the Q&A box, and so I'll start with, would be interested in whether or not it is helpful for BVI government, for those responding to the consultation, to highlight areas of agreement with the policy, as well as where they disagree, would like improvements.
Yes, that is what we want. We want persons to be very candid, very open, and identify the areas that they see room for improvement, but not only identify them, but also give us suggestions and recommendations about where and what could be improved, because that's useful. So probably going further than the question asked, but one of the things that we intend to do is collate, obviously, the responses at the end of the period, and we will likely have another session around what the results were and discuss where we end up based on the responses. So that is the direction of travel as it relates to the consultation, because I don't think it's useful for stakeholders to not appreciate what has actually been said about the document, good, bad, or in between, and then ultimately having an understanding of where the policy would end up based on those responses received.
There's a question regarding some of the recent discussion that has happened in the UK. Of course, the Premier has issued a statement yesterday addressing some of those criticisms that came out in the UK from the media and parliamentarians. Ayanna, do you want to cover some of the main points that were addressed in the Premier's statement yesterday?
I think the statement itself essentially just reinforced what the jurisdiction has been doing, leading the way, being one of the first to sign on to the Common Reporting Standard, always being committed, again, like I said very early in my talk, to the fight against illicit activity, very actively producing information for law enforcement to take action against bad actors. I think, and we have continued to engage with the United Kingdom generally on this process, this consultation, where we are. So there's been nothing that has been hidden from sight. But again, the one thing around beneficial ownership information, our register has always been verified. We've always had the information. We've always been able to share it where it's been accurately identified to take to, like I say, the next step of law enforcement. I don't want to really harp on what has been going on and playing itself out in the media, but I really want to just continue to stress that we have this policy draft being circulated, and we really need stakeholders to formally respond. We've had a lot of informal discussions, but I think we as a jurisdiction have to get this in writing from our stakeholders. So I don't want to harp too much on that discourse.
So,
The
Ayanna, you addressed it earlier in your overview, which was excellent. But I think the notion is the idea that this is the first time that we are providing beneficial ownership information. And you mentioned, boss, and that we have continued to work with UK law enforcement authorities. So can you just drive home that point? I think that point needs to be driven home.
Yes, I refer to the UK Exchange of Notes framework. Um, I know there may be questions as to why there isn't a category that may refer to UK law enforcement, for example, having access or being part of that eligible category. But it's very important to understand that legitimate interest doesn't apply to law enforcement. They have a direct role in the fight and investigations and prosecutions. So we've that exchange of notes framework has been very effective, based on the conversations that we have had as the government is not directly involved, but based on the conversations we have certainly had around that. Um, we have had instances where UK law enforcement has received information within an hour. And we understand that the FIA and UK law enforcement work very closely. They have very good relationships. And these requests are processed without any issues and has been that way for quite some time. I think it's been in place since 2017. So it's not something that just happened yesterday. It's actually several years of evidence around it. Um, there have been a number of requests. I think the last number that I heard, maybe about a year or so ago, would have been 8,000. And there has been no concern raised with those 8,000 requests. I think the United Kingdom probably has benefited the most from the information that we host in BOSS, over the last few years.
So this is just another evolution in the process of sharing beneficial ownership information. So I'm going to go into the next question. Of course, people have questions about when are we going to receive more information on the types and the amounts of fees that will be charged.
That will be charged for the beneficial ownership requests or the search.
The search. You mentioned that
Well,
there's
yes.
always a cost associated with
Yes.
burden.
So it is anticipated that the search fee would not be anything outside of the normal range of fees at the registry. We're having these discussions with the commission, and when we have more, when we've received all this feedback, it's one of the areas that we are going to then utilize and inform at that stage. Because again, the policy is still in draft form, the framework has to be developed, and the amounts will form part of that secondary discussion I mentioned when we're discussing what the responses have been. But it will not be outside what persons have seen for searches, um, at the registry.
There is no question of voluntary liquidators or insolvency practitioners. Have these professionals been considered for being included in legitimate interest categories?
They have not. But again, one of the pointed questions to the consultation is if there are other categories that persons feel should be included, then please add them to the list. Because we've, based on internal conversations, even with our focus group, we've identified where particular professions would have use for this information, and actually some instances where the beneficial owner would welcome this information to be shared. So if you deem other categories should be included, please do add them to the list when you're responding to the consultation.
Can you provide more detail on what information is proposed to be provided on the nature of interest? Would it recommend that this is restricted to bands of ownership and control rather than specific interests? You
If
need
the
me to
question,
repeat?
no. If the question is speaking to when we've decided, when the person making the request has been granted access and the scope of the data that we're providing, one of the pieces, is the nature of ownership. So the intentions are to provide percentages of the individual's ownership or control in the entity. And again, oh, one of the things that I really want to clarify, because I know this has come up, around what percentage. the percentage is 25% or more. So just want to reiterate that.
Will the beneficial owner be required to provide reasons for his/her refusal for access to that information? Or can they simply just refuse access?
No, they have to provide justification. And we've tried to give some steering guidance around what that should look like. I think it is, I would refer the person asking the question to clause, where am I? At page 8 of the draft document, clause 7, and it kind of gives you an idea of the types of information that the beneficial owner should be providing in order to give the registrar sufficient information to make a decision.
How long will the analysis for exemption is expected to take?
Well, it depends on the information received. When I say information received, not what has been provided for a particular case, but the number that's been received. One of the things that we are contemplating is to have an exemption process prior to the introduction of the legitimate interest filter. Again, that would help to, I guess, relieve some of the pressure in terms of quantity, because you may have persons waiting until somebody requests the information to seek the exemption. So we want to have the exemption process not be triggered by a request, but rather occur in advance, because we feel that would help the process. The more information that's provided to support the exemption request will definitely speed the process. This particular time scale has not been defined, but again, we are not. It's a very sensitive issue. It's a new space for the Virgin Islands, so putting specific timeframes is very difficult. But again, at the inception or rollout of a legitimate interest register, I think our goal is to have the exemptions actually occur before the process starts.
So
So
the exemptions be considered standing, or will they have to be made every time upon each request? Or will it, once you get an exemption, does it stand, or you have to?
once you have an exemption, your information, and FSC terminology around how the system will work. But just for this conversation, I will say your information is flagged. So if the information is requested, the registrar will already know whose information has received approval for the exemption, and as such, the information would not be shared. But as I mentioned earlier, the exemption will be subject to a review process. So it would not just be standing, and it would depend on the circumstances of the exemption. I use the minor because that is the simplest one, because we know that that will have a very firm date as to when they will no longer be a minor. The others, again, those review dates would have to be determined based on a number of factors, which I would leave to the registrar to determine.
The next question is really about the commission and what it's doing to protect data. So it's not really for you from hackers, but the commission had a meet the regulator in December, and they provided a very comprehensive overview of what they're doing in terms of security. And that information is available on the commission's website, or we can also send that information out to you. So I'll move on to the next question. If a beneficial owner applies for an exemption, for example, out of fear of kidnapping, would that mean the information would be held back and not released even after receiving a legitimate interest request from a government authority? Would this particular exemption have to be renewed?
So to be clear, exemptions only apply to persons who are in this eligible category, whomever they are determined to be at the end of this consultation process. Law enforcement competent authorities will always have access to the scope as they've had since inception to beneficial ownership information. So they do not qualify for this exemption process. Again, it only applies in circumstances where persons other than or groups other than law enforcement or competent authorities have requested this information. So if they've received, if the registrar receives a legitimate interest request on a person that has received an exemption because of kidnapping concerns, that request will not be honored.
So just to, I guess, reconfirm what you're saying is that already government and competent authorities have existing access to that information, and that's not going to change.
That is correct. And so to be clear, government meaning law enforcement. Law enforcement and competent authorities domestically continue to have access. That has not changed since we've introduced a register of beneficial owners.
Okay. Is there a mechanism for a legitimate interest person to request the information confidentially? For example, when an insolvency practitioner or legal professional is investigated as suspected financial or business misconduct, where if the BO is alerted or the request, it may be put, it would put the investigation at risk.
That's an interesting question. I don't believe that this type of scenario was factored into the document, but I would appreciate if whomever is asking the question provide that formally in writing. I will take it back to see how that would work, because again, it's very clear for law enforcement and competent authorities. They access the information. The tipping off concerns are there, but there may be categories in this group where tipping off may be a concern, as presented in that particular scenario. So yeah, let me take that one back. And as I said, whomever has asked the question, please provide that as part of the consultation process.
We'll have the list of questions for today available and provide additional information. So also, we encourage persons to formally, as Ayanna said, submit these scenarios to the consultation. Anything that you submit to the consultation would be useful. Will access be only Virgin BO register? That is, any request will not include historic information in BOSS.
So there are two things happening now. Obviously, with the transition to Virgin Boss, new business at the start of this year has been inputted into the system, new beneficial ownership information, and there is an intention for bulk filings to occur later on in 2025. Those bulk filings are meant to deal with the companies that were existing at the time the regulations took effect. So that would be the existing company's information on beneficial ownership. As I understand it, the information will be requested as at a point in time. So I can't speak to how the commission is going to inform the industry around what the bulk upload will look like, whether or not it will include historical information on the entity or beneficial ownership as at a particular point in time. Whatever is in the registry at the date of the request because again, it is existing information. So at the time of the request, whomever is the beneficial owner at that time will be shared with the relevant requester. I hope that answers the question. Because there are two things, because there are new companies, there are existing companies. When the existing company's information are populated in Virgin Boss, whomever has been identified as the current beneficial owner will be the information that is shared. Owner or owners will be the information that is shared.
Okay, well, I think a point needs to be clarified also that they're not taking boss information and transferring it into Virgin.
That is correct. The industry will receive instructions to upload from their own respective databases. I can confirm that the commission will have BOSS information, but it will not be part or populated into Virgin BOSS.
You have a name for it, Virgin Boss, Diana?
That's what I call it because I have to differentiate between the two.
Okay. Will there be a publicly accessible register of persons who have been granted legitimate interest access to BO registers?
No. The intentions are for that information to be held by the commission. It will be useful for them in terms of reporting and monitoring of requests. Um, so no, it wouldn't be made public as to who has been granted access. I mean, as I mentioned, it works the same way that other searches work. We would never publish who has accessed the registry for searches. So we wouldn't do it just because it's beneficial ownership information.
Will the liquidators and insolvency professionals be able to file the BO info during the course of liquidation?
That's a good question because again, it would be determined based on how the system has been developed. Even though I can't speak to any type of confidence on how the commission has advised the industry on and again this will relate to bulk information and even for existing companies, but companies that were set up since the year started, it will depend on whether the system will permit that type of change to happen. So I can take that back and ask the question. But I can't speak to any confidence around whether or not that information would be able to be uploaded in that scenario.
I'm going to ask this question, but this is the point of the consultation. Who will have access to the ultimate beneficial owner information? Any person or just authorities?
Well, it goes back to the categories of persons who will be eligible. As I mentioned, we put forward a number of categories. Um, we've had a couple mentioned during this Q&A session that there are possible additional categories. But again, it's up to you in response to our consultation process, whether or not the categories that we've listed are sufficient and whether you think others should be added.
Okay, how will the BO be contacted if a request is made for their information? Is it via the registered agent or directly?
That question has arisen, and it's a discussion point internally. Uh, the when we think about, and I will use for those familiar with the Virgin system and how it works, you will note if you're transferring a company, for example, it triggers an automated email to the new agent to essentially approve or reject or and it sits there for a defined period of time. We have contemplated whether or not that same type of process would be used in this instance. So it would essentially go to the agent. Another question has come up during our focus group discussions around whether it makes sense to go directly to someone else. And that someone else may be the client of record for this company, it may be the UBO themselves. And again, going back to the time frame that's been granted for the BO to respond, um, it being relatively short. So it's an internal discussion, and for that we would love to get feedback as well. It wasn't one of the questions on the list, but certainly on that point, whether persons feel it's better and more efficient to continue to flow through the agent, given the fact that BVI companies are so spread across the globe, different time zones, et cetera, and the proposed 5-day time frame. I think we've asked if the 5-day time frame is sufficient, but we would love to get feedback on who should be the contact, UBO directly, registered agent, or the client of record.
The next question is, the regime requires beneficial ownership reporting of exact percentages. Example, 27% or 39%. This is very onerous for BVI entities. Even the tiniest change in ownership triggers a full new filing. Is that burden understood by the authorities? It is very unattractive for users of BVI, as the BVI been required by international stakeholders to mandate such a prescriptive, onerous approach to BO filings. What would be much more attractive would be for percentages of ownership to only trigger new filings where the relevant bands were passed. That is, where ownership exceeded 10% or 25%. And I think you already said it was 25%.
Yes, for this consultation and anyone who accesses through legitimate interest, the threshold is 25%. But I think the question is speaking to the broader concerns with what is being what's being asked by the industry to upload into the register now, which is outside, broader than even the legitimate interest access policy. I will take that point back to the commission. I can say here that the commission has, many of you will know, been to Asia, been to Europe, talking about the new changes to the legislation. And I am aware that there are a number of things that they're looking at when it comes to the BO register and the information that's being shared there. So I'm not sure if this particular concern was raised around having bands of percentages versus exact percentages, but I will take it back to them because I know that it's a space that is under consideration in the commission based on a number of concerns raised during their visits across the way.
Can you please confirm what the intended approach will be for local registered office providers who are unable to obtain beneficial ownership information despite best efforts? For example, will there be inspections and potential fines on both the client company and the registered office provider?
To answer that question, I will say this. The obligations of a licensed registered agent has always been to hold this information. What is happening now is they're just being asked to put this information into Virgin Boss. And so I would not expect an agent to be acting for a company that they haven't been able to identify who their beneficial owner is. And as such, to answer that question, yes, you would likely be subjected to a fine, and not because the information necessarily is in Virgin Boss, but on the foundation level, this information should be had because it's required by law, and it's been required for many, many years, even before we had an electronic system. So whomever that is, if you are acting for persons, I would suggest you take a look at your business and make some decisions on your way forward.
With respect to funds, will the name of the specified person be provided to the inquirer or that the fund is exempt from filing BO data?
I can't speak um, to this issue at this time because I've had some very, very brief conversations with the FSC. Again, it goes back to who may be exempt and who is not exempt from filing information in the register, and that dictates then what is accessible or not. I know that there's an ongoing discussion around funds um, and considerations around the requirements. So I don't want to preempt and say exactly what would be shared, but whatever will be shared will be what has been provided for through through the BO regulations that have been prepared. So if it's a specified person, then that will be shared. If it's something else, that will be shared. So it all is dependent upon what where we end up on funds.
Okay. If a request for information is rejected on the basis of an exemption, would the BVI explain to the person making the request why the exemption is in place? Or would they just say no to the request without further explanation?
This has come up in our focus group discussions about when there's a rejection, what should we actually say? Um, and one of the proposals is around saying no in the case of an exemption, that no, the the particular entity has been granted an exemption, and refer them back to how an entity can receive an exemption. So take it back to the provisions. There's been concern that we may have to be more specific, again, going back to the appeal process, whether or not more information would have to be given around why the rejection was actually determined. But again, persons can contribute to this discussion as well because it is something that I don't think we ourselves have decided what should be said. Um, Typically now when items are rejected, the registrar does provide a reason when filings are rejected, but it's about how much information can actually be said, and especially in cases where there are disproportionate risks like kidnapping, etc., whether or not you really want to exactly say that the reason is for that purpose or be very broad. So we're happy to receive any thoughts on that. Um, but as of now, the intention is not to just say no, but say under general grounds, whether it's because of exemption or because of representations made by the BO. So very broad reasons without much detail.
Okay, this next question is actually the point of the consultation, but I'm going to ask it. Are there restrictions on who can request information?
Well, again, goes back to the categories. Whomever is determined to form part of those eligible categories um, will be the persons that can access. So again, contribute to the conversation and identify any persons you think should be added um, if you don't feel the categories provided are sufficient.
Okay. You've clarified that domestic authorities have always had access and will continue to have access to information. Does this apply to international authorities as well? Meaning, if a request is received from law enforcement of beneficial owners' native country, would the information be shared even if the beneficial owner has an exemption?
I think this was asked in a different way. So yes, because you will recall that law enforcement competent authorities have their own information sharing mechanisms that we would use to determine whether or not a request is valid and then go through the process. So yes, they've always had access, whether there was a electronic register or otherwise, they've always been able to get that information, whether they make the request to the registered agent or whomever holds the information, and they share it with their counterparts. So that mechanism has not changed.
If a request is rejected, information request is rejected on the basis of an exemption, would the company be informed that a request that had been made and rejected due to the exemption, and who made the request?
I think I made the point that even with um, whether when the request is received, the beneficial owner would be informed. I think we have been toying with what information will be told to the beneficial owner, how much information on the requesting party will be shared, um, but they will be notified. So the decision taken by the registrar will be notified to two persons. So that's why I use the transfer of a company as an example, because when the transfer occurs, both agents are notified. The same would work in this instance. The requester will be notified of the decision and the beneficial owner will be notified of the decision. It's the only way then, if there's an appeal necessary or either party wants to appeal, they would know what the decision taken has been.
What happens if the BO does not respond to the notification of the request, neither approves or objects? Will it be shared anyway?
At the end of the process, yes.
Okay. Do you have a date for when these bulk filings will be available?
No, I don't. No, I don't. I know the commission is working feverishly on getting the bulk filing platform finalized. I think they did give a date going back to their meet the regulator in December. I don't know that that date has changed, but certainly if you can access the FSC's website, there was a presentation that was very specific about the dates when different pieces of the Virgin Boss platform and other Virgin pieces would be made available for populating. So I would just refer you to that. My view is that they are still on that schedule, and I suspect that if there's a change, they will alert the industry of that change.
Okay. In order to request information on beneficial owners, the consultation paper section 7.1 says the details of the relevant legal entity and the beneficial owner need to be provided in the request. This indicates that details of the beneficial owner already need to be known to the requester. Is that the intention?
Sorry, it goes back to the whole concern around fishing expeditions, right? Typically, if you're looking for a particular person, then yes, it would be good to verify who that person is. So I'll give an example. Let's say that I am a lawyer being asked to issue an opinion, and I want to verify that the beneficial owner I've been advised is the beneficial owner, is that person. I will know the entity, I will know the beneficial owner. And so, therefore, it's expected that you would know that. Now, the question arises around other parties and other requests, possibly from a CSO, civil society organization, sorry for the acronym use, or other one of those categories who may not know who the beneficial owner is, but definitely know that they want to know who this entity relates to. Um, so there may be scope for variation of that request. So again, it's a consultation document. If persons feel that that's too much detail for the requester to provide because they're actually trying to confirm this information themselves, then please provide your comments around that space. But certainly that was the idea, that some instances the beneficial owner will be known, or has been provided, and it's someone that's trying to verify that that is indeed the person. And again, if the beneficial owner they provide isn't the beneficial owner, they're approved for access, they will be provided with who the beneficial owner is. So it works either way. But again, happy to have comments back on that particular list of items that the requester must provide.
Does it mean that only the current beneficial owner will be shared?
Well, we use this the same way we've done with directors. When we started to allow persons to search for list of directors, it would only be the current directors that's shared. So it'd be the same approach that's applied in this instance, not just because it's a beneficial owner.
If a request is made for a company that was struck off before January 1st, 2025, the requester will be informed that there is no information in Virgin Boss.
The legitimate interest access process would only be in place with Virgin Boss being populated. So again, referring back to the bulk filing and that being uploaded, that being required because the intentions are for the information to be there. I mentioned also that the commission will have whatever boss information exists and they will have access to that information. I don't know how they would utilize that if we introduced legitimate interest access prior to bulk filing being submitted, or whether or not they are more comfortable waiting until Virgin Boss is fully populated to then introduce the filter. So those are conversations that certainly have to be had. But the intention is not to say there's no information, because there is information. It may not be in the system as yet, but there is information. And how and if that is processed in that manner in the absence of the information being in Virgin Boss is a conversation to be had with the commission.
Okay. A previous answer that you provided referred to obligations of the registered agents to know who the beneficial owners are under AML legislation. However, this overlooks the fact that the obligation to file a beneficial ownership register is on the company, not the RA. So there remains a possible situation where the RA knows or thinks they know who the beneficial owner is, but the company has not approved the filing. And RE cannot make the filing on behalf of the entity unless the entity has approved it. Not a question, a comment, or an answer previously given.
Duly noted. So to answer the question, so since you've explained and clarified around what the question was, which is in relation to what is filed through a register of beneficial owners. I think the question when it was first said was about not knowing who the beneficial owner is, which is a different conversation. So yes, that particular provision I think has some challenges. I don't know if that was one of those that was raised as an issue in the commission's trip to Asia and Europe and as well domestically. So I can't speak to whether or not they will take any type of action if that cannot be done. But again, that is not my space, so I can't speak with confidence around what the FSC will or will not do if you fail to upload the register as required. Um, my role is simply to point out that agents should know who their beneficial owner is. Um, that other aspect of it is something for the commission.
Looks like we have to have a session with the commission.
Yes, based on what I understand.
Yes. Does the recently enacted BC and LP limited partnership amendment and BO regulations replace the BOSS Act in terms of beneficial ownership information?
The intentions are for that legislation to eventually either fall away or reference the new regulations. That is a discussion that is ongoing. But certainly beneficial ownership information as it relates to populating any system should be guided by the beneficial ownership regulations at this time.
How will requests where there is no UBO be treated? Example, where the parent company is a Cayman Foundation.
That is one of the scenarios, and I believe the commission is working through. So again, that's not necessarily a legitimate interest access issue, more so than a data upload issue. So that would be a question for them.
There does not seem to be an express exemption in the BCA that a BVI company can rely on for not obtaining BO information where its ultimate parent is an SEC listed entity or listed on a recognized exchange. Is this the intention? The RA as a licensed entity would ordinarily rely on this, but the law and regulations as drafted don't exempt the BVI company from obtaining the BO info from a listed company. This presumably is something that will be fixed.
My short answer is likely to be. But again, that is something for the FSC, the clarity on whether publicly traded companies are exempted and whether or not information that's required may just be the platform on which it's traded. So yes, I would say that that would need to be clarified by the commission.
Okay. Given that the UK has come out strongly against our proposed legitimate access regime, how confident are we that this is sound and able to withstand further scrutiny? Further, is this consistent with the other UK territories?
What I will say is that, I sat on a panel 2 days ago with colleagues from Anguilla and Cayman. We're all trying to find that that ground that suits our individual jurisdictions in the absence of an international standard. I mean, when you think about the FATF standard around beneficial ownership information, it's very clear as to what needs to happen. It gives you guidance on how to introduce it in your respective jurisdictions. But given that there's such a wide range of registers that exist, um, our goal is to make sure that we continue to be a trusted jurisdiction, continue to be competitive, not shy away from our role to fight illicit activity on the front lines, engage with our OT counterparts, our crown dependencies, understanding their own approach to this. Many of them have taken a phased approach. Jersey, for example, has opted to only at this point extend access to their domestically regulated entities, and have opted to wait and see how the EU's guidance on legitimate interest access plays out. But we continue to monitor what's happening in all spaces because, again, without an international standard, essentially you're trying to determine what is the best practice, what is the best approach, and what is useful for your jurisdiction to be trusted but also remain competitive. So I think balancing that, being responsible, being transparent, respecting privacy of the data subjects that we've been given responsibility of their information are all critical pieces that have to be considered. So that is my view. And I say we continue to engage with our counterparts. All of them have had different approaches. Some are on different timelines. Some have gone further. Some have already consulted. We are in the consultation phase. And I think only once we've completed this will we know our next step um, to introducing legitimate interest access.
Okay, thank
And
you.
again, we welcome feedback. And feedback is,
Input.
input. We've provided an email address, and whomever wishes to provide feedback is very welcome. because again, all of it is going to be collated towards coming up with a solution that's suitable for the jurisdiction.
Okay, I just received a note from the Financial Services Commission saying that the majority of the questions that are being asked, which are directed to the Financial Services Commission, has been asked in, their previous forum, their recently held forum in Hong Kong and I guess London, for example, and that they are preparing responses and a guidance will be issued on those questions. So we should expect to receive that guidance and the response to those questions from the commission since they have already received them. Thank you very much, the commission, for providing
Yes.
that note to me.
Mhm.
Where a person is a beneficial owner by control rather than an ownership 25% threshold, their information would not be accessible, correct? Only persons with a 25% interest or more would be available.
That is not correct. So if you will recall, I said the information to be shared refers to nature of ownership. So in an instance where it's based on control, the person identified would be the person with control. So I just wanted to clarify on the ownership shareholding that the threshold is 25%. I know there was concern that persons are being asked to upload 10% thresholds. So I just wanted to clarify that under the former BOSS system and Virgin BOSS, the threshold to be shared to these eligible categories, whomever they become, will be 25% or more. And then the nature of ownership is the way we've termed it. So it would either be based on shareholding or control.
Okay. How will it be vetted that journalists are bona fide, that is not bloggers or something similar?
Those conversations are being held internally. We are engaging, again, as I said, the FSC are the responsible authority for this register. And as such, we have been engaging them on how applications will be assessed. So that's an internal process, just to identify that when competent authorities, law enforcement receive requests, they have their own internal vetting standards and requirements, and the same will apply in this instance. And that is not usually shared to the public. There needs to be a level of, um, I don't want to use the word trust, but I'll use it loosely. Trust that the application once received um, is vetted to a standard that's been determined um, in order to make a decision on whether or not to share that information.
Okay. Are the authorities aware that there are types of BO filings that are mandatory under the current law that cannot currently be made on Virgin? For example, the filing of BO information where the BVI company is a subsidiary of another BVI entity.
Again, an FSC question. So hopefully this is another one that they have received before, and they will add to their list if not.
Okay. Regarding the timeline for response, how much time is given to the BO or the RE? Is it 15 days, 30 days, etc.?
I think the proposed time period is 5 days.
Okay. In the request process for access clause 7, it indicates that each request must include amounts other both 1, details of the legal entity, and 2, details of the BO whose information is being sought. If there's no match between the BO whose info is being sought and the actual BO of the company, will the request be rejected without providing the information of the actual BO to avoid fishing expeditions?
That's also a good question. I will take that one back because I don't believe that we've contemplated contemplating where the beneficial owner provided that's not the same, whether or not that would be deemed to be a fishing expedition. I think yeah, that's an interesting scenario. So I'll
Uh,
take that one back.
okay. Uh, this is another question which I think, okay, let me ask you. Would it make sense to align the AML beneficial owner interest percentage with the 25% used for this policy? The FATF required that the threshold should not exceed 25%. The amount on the ROs, et cetera, having two UBO thresholds seems onerous and unnecessary. If we move to the AML UBO threshold to 25% too, would mean the BVI is still aligned with the international standards and the FATF recommendations. Essentially, can we have one threshold instead of two?
I believe that was discussed heavily during the BCAP consultation, and the commission, I think, responded on the reason why there were going to be um, two, the realities around reducing or increasing an amount that has been in place since I don't even know how long, um, and the potential challenges around that. So I think that was discussed, and I wouldn't want to not speak truth to what was actually shared, but I do know that it was a question raised during the BC Act consultation process, and a response was given around why the 10% had to stay.
Okay, I see we have a number of questions. The majority of them seem to be, again, FSC specific questions. And so we will make sure that these questions get to the FSC and that they will be part of their document that they are producing shortly to answer these queries. I am going to try to wrap up now. It's 17 past. And so I am going to allow Ayana to give our wrap up. Unless there are any pressing questions, let me just look quickly to see if there's anything specifically that I think that was not addressed previously or that is so important that we need to ask you to address it here. But I think based on what I've seen, these can all be sent to the FSC. And I just want to say furthermore, Ayana, can you provide the email address again for the consultation? And these questions can also be submitted as part of the consultation. So Ayana, can you provide that?
Yes, I was just about to, in my closing, to just say I want to thank everyone again for making yourselves available, for joining us. I hope that the discourse this morning was useful and helps you to clarify and clear your minds as to what we're trying to achieve, which is a policy that balances transparency and privacy at the same time, remaining a competitive jurisdiction in the absence of international standards per se, but recognizing best practices in the space. Um, the consultation ends on the 28th of February, 2025, and the email address where your comments can be shared are boconsultation@gov.vg. Um, it's a pleasure to have had these questions asked, and we really appreciate so many of you joining us. Again, it shows that persons are engaged in this process, recognizing it's a shift from the norm, and it's something that requires substantial input. We're hoping that all our stakeholders, not just domestically, those in Asia, in Europe, Latin America, wherever BVI companies are used, join and contribute to this discussion because it affects us all. So thank you again, Elise, for encouraging us to do this. And as I said, once we have received the feedback, our goal will be to collate what we've received and re-engage with the industry.
I want to thank Ayanna very much for providing this very detailed and insightful information on the consultation. I want to emphasize that your voices, your input is extremely important. And I want to say this because there are a number of persons who are not involved in our financial services industry, who have very loud voices and have already started to put their input. So it is essential that the people who are actually engaged in this work, the people who are actually engaged in our industry, be the ones that are given significant input. So we cannot underscore enough how important it is for you to be part of this process and for you to put as much as possible, you and your colleagues get your input in, because your voices must be heard and your input is crucial, other than the voices that we've already heard, which critiques our jurisdiction, but are not really involved in this process. So I just want to emphasize input, 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 input as much as possible. Take your time and as detailed as possible, put your information as part of this consultation to the email address that Ayanna has sent. And I'm sure she's open to you contacting her directly, also to sharing your input. This has been another BVI Finance Breakfast Forum. I thank you so much, all 270 plus, I think I saw of you at peak, for joining us for this breakfast forum, wherever you are. We were pleased to have you join us. And I want to thank Ayanna again for taking the time to join us for another BVI Finance Breakfast Forum. Just 2 points I want to emphasize. The commission has said that it's preparing a guidance and a document that outlines many of the questions that have been asked here this morning. So we'll be looking out for that. And again, I just wanted to say that this process is important. And so make sure that you are part of the process. This has been another BVI Finance Breakfast Forum. Thank you, Ayanna, for joining us. And thank you for this opportunity to have this conversation with you.
Thank you.